One of the most important topic under law of contracts is consideration. Consideration is one of the essential element of a valid contract as per section 10. So, if a contract is missing consideration, it is not a valid contract. Now, the question is, why consideration is so important that the lack of it makes a contract invalid? As has been explained in part 1 of this course, a contract is all about give and take, and this give and take is called consideration. If an agreement only requires a person to give without getting something back in return, or if an agreement requires a person to only take without giving something back, it becomes a favor rather than a contract. And when someone who promised to do you a favor later denies to give you that favor, then you can't go to court forcing someone to give you that favor. Because it is a one-sided promise. The person who promised you a favor is not getting anything from you, so why should he be obliged to do something for you? Obviously, this might spoil your relations with that person, but from a legal perspective you cannot go to court saying that a person promised you some favor and now he is not giving you that favor. The court will help you only when you show the court that you have fulfilled or ready to fulfill your promise, but the other person is not willing to perform his part of promise. This is why a contract which lacks consideration is not enforceable in court of law and is invalid. You cannot compel a person to do a favor or gratuitous act. Now take an example. Mr. A promised to Mr. B to voluntarily teach mathematics to Mr. B's son for his upcoming exams. Mr. A later refused to teach Mr. B's son, and as a result Mr. B's son failed in his mathematics exam. Now, do you think Mr. B can sue Mr. A in the court of law? No, he cannot. Reason being, there is no consideration in this contract. Mr. A was just kind enough to offer Mr. B to teach his son. But it was just a favor. It was supposed to be a gratuitous act. It may be morally or ethically wrong to promise someone and later not fulfill the promise, but it is not legally incorrect. Law will not help in such cases, and these kinds of cases are not fit to be dealt by court of law. Now take a similar kind of example again. Mr. A promised to Mr. B to teach mathematics to Mr. B's son for his upcoming exams, and Mr. B promised to pay Rs 5,000 to Mr. A for doing so. Now, here things become altogether different. This contract has consideration. There is give and take from both sides. Here Mr. A is not doing any favor to Mr. B, in fact, he is getting Rs 5,000 from Mr. B. So, this is very much a binding contract, and Mr. A or B, both can go to court if anyone fails to fulfill its promise.